Dunn. The question is the report be noted. Ms Couteur.
Fellow committee members, and echo Mrs Dunn's comments about the collegiate way in which we worked. Of course, also the committee secretary and all of those who'd made submissions or appeared before the committee. I 100% support the basic idea behind this legislation. I'm totally of the view that drug issues should be treated as health issues. As has been mentioned, alcohol and tobacco both cause more health issues than cannabis, and they are legal. As a society, we have done the experiment with alcohol, and prohibition does not work. What you get with prohibition is whatever health issues there may be with that drug, plus a criminal element who can make money out of supplying the drug. The evidence given to the committee in the course of the inquiry makes it abundantly clear that having an inquiry actually was worthwhile, because there are some quite substantive issues with this legislation, most of which Mrs Dunn touched upon, but I will speak more of a different emphasis. The main issue from my point of view is, can the ACT pass legislation that will effectively legalise personal use and cultivation of a small quantity of cannabis, given Commonwealth law? If we can, there are of course a number of other issues with the implementation of this legislation that the committee has commented on, but the number one issue, the main issue which I'll discuss first, is can the ACT go it alone on cannabis legislation? Is it legal? Can we make it legal somehow, given the Commonwealth legislation? The committee asked the Solicitor General about this, and as a non-legal person, I interpret his evidence as a definite don't know. In fact, what he said was, this is what Mr Garrison said, if I might be so bold as to say that there are many laws that have been drafted over the years that one is confident will withstand legal challenge, and it would be very bold to assert that it will until such time as the challenge occurs, so that all that can be done is anticipate what those challenges might be in terms of ensuring that if the bill is to move forward, the provisions are drafted in a careful way as possible to minimise the prospect that it does not, double negative, amount to a justification or excuse. In other words, that it is a justification or excuse, end quote. However, the Australian Federal Police was much clearer in its views. Ms Smith, who's the president of the Australian Federal Police Association, said that over the course of the past few weeks, I've had the opportunity to speak to a number of ACT, AFPA members about the bill, and all are opposed. Mrs Dunn, at a subsequent hearing, asked Assistant Commissioner Johnson, as Commonwealth officers, would you be obliged to charge under Commonwealth laws because we had abandoned the field? Assistant Commissioner Johnson replied, and I quote, obliged is the wrong word. I think it comes back to discretion. Each constable has their own discretion and is responsible for the decisions they make. I'm at pains to say that all our officers are keen to do the bidding of the government in terms of achieving policy outcomes, and their use of scones and so forth is part of that effort. I'm not for a minute suggesting that if this was passed suddenly, everyone would be being arrested all over the place under Commonwealth law. But police officers have responsibility to turn their minds to it, and I cannot guarantee that, depending on the circumstances of the day or the time, a charge might not be laid under Commonwealth law. The other thing that comes into play is that because under Commonwealth law it remains an offence to possess, while a police officer may choose not to take a prosecutory path, they are left with a decision about whether to seize the cannabis, which still leaves them in an awkward position. Our very strong direction to members now is that you have a very clear way to ensure your own integrity. If you're not going to take action on a particular matter, you need to handle what is an illicit substance very carefully, seize it appropriately, record it appropriately, etc. So there are issues with not only the potential for a charge to be laid, but also what we do about possession and what advice we would give to our members about how they handle it. That is the other key part of my concern about how we will operationalise it. End of quote. I asked the government a series of questions on notice about the legal protections given by the bill. Their summing up answer was not inspiring, and I quote, "The government is working towards a model that would give ACT residents confidence about the type of conduct and circumstances that would be lawful under the proposed amendments," end quote. More cheerfully, however, the committee did hear evidence from the Law Society that there may be a solution to the legal problems. They suggested the inclusion of express authorisation, what they said, and I quote, "Expressly stating that it is an authorisation in the legislation would seem to be at least avoid vacating the field. The Commonwealth do not seem to have expressed a desire to cover the field themselves, but in the absence of any other law, that would seem to be the issue," end quote. So, it remains unclear as to whether or not Mr Patterson's bill can achieve its objective. If it does not, but Canberrans think that it has, then there, of course, as Mrs Dunn also pointed out, there are possible criminal implications for people who may believe that they can safely grow and possess cannabis for personal use. This is why the committee made 3 recommendations on legal issues. The first is recommendation 10, which says the committee recommends that section 171AA of the Drugs of Dependence Personal Cannabis Use Amendment Bill 2018 be amended to include express authorisation for the cultivation and use of cannabis by individuals for personal use. End of recommendation. And this is based on the evidence from the Law Society